think we'll begin by having you just tell us a little bit about the current status of heart pacemakers and, if you will, defibrillators.
Steve, today, some 2.5 decades since Chardic's success that you mentioned earlier, about 1 out of 300 Americans over age 55 depends on a pacemaker. And it is estimated that the number of implanted cardiac pacemakers may double by 1990. Among the reasons for this continuous growth of the number of pacemaker patients is the improved knowledge and diagnosis of irregular heart rhythm, plus the availability of better pacing systems. Now, within the last 3 years, the automatic implantable defibrillator has also been utilized successfully in human beings to terminate ventricular fibrillation and in particular ventricular tachycardias. And later versions of what is called the Mirowski defibrillator shows improved performance, and this is used in defibrillation as well as in trying to interrogate the defibrillator. And Mirowski himself, who is the inventor of the defibrillator, foresees the day when both a pacemaker and a defibrillator will be incorporated in one device, and a more comprehensive approach to cardiac arrhythmias will be dealt with. There is also a new defibrillator that's been produced by Dr. Zipes of Indiana, and this has been implanted in several patients during the past year. The interesting thing about the Zipes defibrillator is that it can be implanted in the chest in a relatively simple procedure without opening the chest. But you know, with advances come attendant duties and responsibilities, and as the number of cardiac implant patients increases, the resultant number of lawsuits have also increased. There's been about 30% increase in the lawsuits and a 60% or more increase in the amount of damages claimed in recent years. And these actions, lawsuits, have been based, if you will, on 3 bases of liability. One is negligence, which we hope to discuss. It's a tort action. The other would be the breach of warranty. And this can be either express or implied warranty. And third, strict liability in tort. You know, pacemaker lawsuits have been brought against the manufacturer, the hospital, the cardiologist, or the attending physician, and the implanting surgeon.
Let's pursue this just a bit. What are some of the specific areas of potential legal liability in these implantable devices?
Well, specific areas, Steve, would be one, the pacemaker, defibrillator, and any other implanted device, you know, carry with them the usual implications of any medical surgical procedure. But there are several areas of unique liability that can be identified. First, for example, tort actions. If a patient is injured because of an implanted pacemaker, may bring a medical malpractice action in tort against the attending physician or the consulting physician and the hospital and the device manufacturer. Now, the patient may allege, among other things, negligence in reaching a decision whether to implant the device when such is clearly medically indicated, or negligent failure to warn of potential side effects or complications, improper selection of the appropriate type of pacing system, negligent post-implantation care, and improper design and manufacture of the device. The indications for implanting a cardiac pacemaker in both the symptomatic and asymptomatic patients are continually being revised. But there are some clear indications which mostly relate to slow heart rhythm or bradycardia. And physicians who are involved in implanting pacemakers or involved with the individuals who implant the pacemakers must be thoroughly familiar with the indications, and more importantly, they should know under which clinical circumstance are pacemaker implantations considered inappropriate. For example, let's take the asymptomatic bradycardia with rates in the 40s, bifascicular block with or without prolongation of PR interval, iatrogenic bradycardia or non-conducted atrial premature beats with invisible P waves that are mistaken for sinus pauses, atypical Mobitz type 1 mistaken for Mobitz type 2 second-degree AV block, and transient sinus bradycardia and or AV block induced by vagal reactions. All of these may be considered clinical circumstances where a pacemaker implantation may be inappropriate. Also, the so-called overdrive failure or overdrive suppression of the ventricular premature beats has been used to implant pacemakers, and here again the pacemaker implantation may sometimes be considered inappropriate. In contrast with pacemakers, the defibrillators, the implanted defibrillator, deals with ventricular tachycardias and fibrillation. Initially, the criteria for implanting the defibrillator were very strict, but more recently the criteria have been relaxed to require only a single episode of ventricular fibrillation or hemodynamically unstable ventricular tachycardia.
Sandy, why don't you name some other specific areas of physician negligence in pacemaker cases for us?
Well, the physician may be liable for failure to use a pacemaker or a defibrillator or other device when indicated, and for negligent failure in the placement of the device which is not medically indicated. Furthermore, say undue delay in implantation of a device may also constitute negligence. The physician today must also consider the non-medical determinants of both the indications and inappropriate use of implantable cardiac devices, the impact of the economy, third-party reimbursements, cost effectiveness, government intervention and legislation, along with individual, personal, and public considerations, as well as case law. These are some of the non-medical determinants of the standard of care for such patients. And then the soaring healthcare costs have become a significant factor in determining the zealousness of the physician's search for the need for defibrillator or pacemaker and other implantable innovative medical devices. And once the need has been found, the question is whether these non-medical determinants play an important role for not implanting such a pacemaker. These are all important in determining the acceptance and performance of such innovative procedure, and secondarily influencing the standard of medical care. You know, all physicians now are becoming quite sensitized to cost containment. Such concerns of the patient, the government, healthcare insurers over the cost of implantable devices will probably result in greater scrutiny of these implantable medical devices. Furthermore, it is conceivable that affordable type of medical care may become a determinant of the legal standard of medical care for such implantable devices. Such the traditional standard of medical care that is set by the medical profession is being redefined.
We've talked here about negligence. Let's take a step further. How about questions of informed consent and refusal as they relate to implant cases?
This is another very important area. Of course, the patient should be fully informed. In fact, should be involved in each phase of the diagnosis and the treatment of the cardiac arrhythmia. This legal duty that is now being imposed by many courts recognizes the patient's right to be informed prior to acceptance or refusal of medical treatment. If a cardiac arrhythmia is included in the differential diagnosis of a physician and the physician chooses not to confirm the diagnosis by further testing, the patient should be informed of this decision and its implications. Also, if the patient refuses additional testing or implantation of the defibrillator or pacemaker device, the patient must be advised of all material risks of his or her decision in refusing such treatment. Permanent devices are generally not indicated unless the patient has a potentially life-threatening arrhythmia. Therefore, negligence in fully informing the patient regarding the decision not to proceed can carry serious liability. And it is well recognized now that a patient that undergoes implantation of a permanent device must give a fully informed consent to that procedure, and the attending or consulting physician may be subjected to allegations of technical battery on grounds of lack of informed consent. And this can occur when there are complications and the plaintiff, the patient, proves that he was not warned of all the material risks involved in the procedure. So the physician may be found negligent there because of lack of informed consent, or by not informing the patient about possible future malfunction. That's the follow-up. The patient should be warned about the possibility of pacemaker malfunction in the future, say due to magnetometers or radar systems and even microwave ovens, although they've become more safe now. Pacemaker patients should be taught how to monitor their own heart rates at home and should know what their heart rate should be. They should be advised about changes in heart rate that may signal malfunction. Generator malfunction can lead to sudden death, and every physician should clearly and fully inform and educate the patient on how to recognize possible warning signs of pacemaker generator failure.
Sandy, what is the physician's duty with respect to medical recordation and follow-up in implant cases?
Well-documented records are essential, Steve. The patient's record should include the pertinent data as to the manufacturer, the model, the serial number, the rate and pulse width of that generator, and equally important should be the documentation regarding the patient's understanding of the device and the patient's compliance with recommended follow-up procedures. Failure or refusal to keep appointments or take medications or participate in, say, transtelephonic pacemaker follow-up should all be noted in the chart. Contributory negligence by the patient or assumption of risk may prevent that patient or plaintiff to recover on a negligence cause of action, and the physician should attempt to inform the patient that refuses to follow up of the consequences of such refusal of follow-up and possible complications. Now, implantation of a particular generator without appropriate electrophysiologic study may now constitute negligence on the part of the physician. For example, it would be improper to place a fixed-rate ventricular pacemaker in a patient that subsequently develops a return of AV conduction and symptomatic competition of the pacemaker and the inherent rhythm. Failure to recognize electrophysiologic signs of pacemaker malfunction can result in inappropriate surgery, as we mentioned earlier, which can lead to medical legal implications.
So far we've talked about types of negligence that involve failure of the physician and or the hospital to adhere to the appropriate standard of care in treating the patient. I presume that these types of malpractice claims deal with the service aspect of implantation. Let's focus now on the claims involving the product itself, the implant itself.
The types of negligence that we discussed involved failure of the physician, as you said, and or the hospital to adhere to an appropriate standard of care in the treatment of the patients. These types of claims, as you said, again, deal with the service aspect, and we should distinguish it from the product aspects. Now, none of the actions discussed so far would include allegations of, say, a defective product. To turn to the lawsuits against the manufacturer of the device, a tort action could be brought against the manufacturer of the device for defective design or manufacture of the product. The manufacturers of defective implantable medical devices may be held liable under several legal theories. Recovery for damages may be based on negligent failure to conform to the appropriate standard of due care in design, manufacture, assembly, packaging, inspection, or testing of the product. However, a strict tort action in negligence poses difficulty in proving all the necessary elements of negligence. And because of these difficulties, a new doctrine arose, the doctrine of strict liability in tort. Under this strict liability in tort, the manufacturer can be held liable for a defect despite the exercise of all possible due care in the design and manufacture of that product. No proof of negligence is necessary. Liability is based on the theory that the manufacturer owes a duty of care to the ultimate consumer to protect that consumer from defects. No contractual relationship between the consumer and the manufacturer need exist. Currently, the trend is to increased and widespread application of this doctrine of strict liability in tort. Now the question is, does this strict liability doctrine extend to the non-manufacturer, the hospital and the doctor, that may sell the product or are engaged in the business of selling the implantable device? The answer to that, most courts have held that neither the physician nor the hospital, who either sell or are engaged in the business of selling the product, are strictly liable. However, hospitals and physicians may incur liability for failure to inspect for discoverable defects.
Sandy, what is the manufacturer's duty in a case like this to warn both doctors and patients of possible dangers of the implantable devices?
Well, the manufacturer liability in this instance can result from failure to warn of dangers, regardless whether the defect exists or not. But the manufacturer will not be subject to strict liability if adequate warnings of all potential hazards are given to the physician and the purchaser, usually the hospital, say. In such cases, the physician's failure to heed and disclose the dangers to the patient is deemed a superseding cause which relieves the manufacturer from liability. But if the dangers and warnings are minimized and downplayed by the physician, the manufacturer may be found negligent, and also if the physician's actions are foreseeable or reasonably foreseeable, then the manufacturer will not be exonerated from liability. In general, the manufacturer will be held to a reasonable man's standard, whether the warning is adequate. And there are 5 relevant standards relevant to the warnings that I have mentioned, and these have been identified. First, the warning must adequately indicate the scope of the danger. Second, the warning must reasonably communicate the extent or seriousness of the harm that could result from misuse of the drug or product. Third, the physical aspect of the warning must be adequate to alert a reasonably prudent person of the danger. Also, a simple directive warning may be inadequate when it fails to indicate the consequences that might arise from failure to follow it. And 5, the means to convey the warning must be adequate. The drug or product manufacturer must bring the warning home to the doctor.
Talk to us about breach of contract. Does this come into play in cases involving implants?
Yes, it does. Breach of contract as in any doctor-patient relationship, Steve, the physician may be liable for breach of contract if the physician guarantees a specific result or cure. Physicians should avoid making any statements which could be misunderstood as an implied or express guarantee of a specific outcome. In general, the reasonable man standard is used to determine whether a contract was made. Would a reasonable man in the patient's situation understand the physician's words as a guarantee? If so, legal liability may result for failure to obtain the promised result. Let me give you an example. A statement such as, "The pacemaker will cure your arrhythmia." Such a statement may be misunderstood by the patient as a guarantee of a specific outcome. Should the arrhythmia not be cured by the pacemaker, the patient may sue the doctor for a breach of contract.
Sandy, let's cover warranties. Now, we are, after all, dealing with a manufactured product, aren't we?
That's right. And warranties always come into play. Most suits against manufacturers are based on either an express or an implied warranty. In general, pacemakers and other devices carry an express warranty for replacement in the event of a defect. Rarely, however, does the patient see this warranty. This, coupled with the fact that the physician selects the brand of implant to be used, makes it very difficult for the patient to prove reliance on an express warranty. Now, to succeed in an action for a breach of express warranty, the patient must prove that there was an express warranty in existence. Second, the scope of coverage of the warranty he must prove, and the reliance on that warranty. Now, in contrast with express warranty, implied warranties include warranties for fitness for a particular purpose, we're dealing with a pacemaker, and warranty for merchantability, has to be safe. To recover under the theory of implied warranty, the patient must prove that the product was defective when it was sold, and because of the defect, the device did not conform to the implied warranty, and three, the defect was the proximate cause of the injury. And in a New York case, the New York court held that expert medical testimony would be necessary in a warranty cause of action case. What happened there is the plaintiff brought an action against Medtronics for breach of express and implied warranty. And evidence at trial showed there were at least three possible reasons why the pacemaker electrode broke, causing the plaintiff's injury. And the court held that the finding by the jury as to the cause of the break, would be highly speculative and presumptuous without expert medical testimony. The jury would have no ground upon which to base a finding of a breach of warranty. The literature that is supplied with the device is not an express warranty as a matter of law. And in this case, the literature dealt with the life expectancy of the power pack. And although there may have been an express warranty as to the power pack, there was none with respect to the electrode that was used. And since there were no allegations that the battery failed, the express warranty was found to be irrelevant.
Let's leave the manufacturer for a time. What are some of the problems that confront specific parties to a lawsuit involving an implanted device? Why don't we begin with the plaintiff's problems here?
The plaintiff may have difficulty if they desire to bring a class action suit based on a defective product. Back in 1977, Medtronic recalled a specific model of a pacemaker for a specific defect. 1 month later, a class action suit was instituted by a patient who was required to undergo a second operation to replace his defective pacemaker. Mr. Rose attempted to sue on behalf of himself as well as 4,000 other patients who were similarly affected by the recall. The court refused to allow such a class action because the defendant's liability, the court stated, could vary from claim to claim, and the damages could range from essentially non-existent to a lawsuit for wrongful death. Also, the pleadings did not suggest a preponderance of common law questions. Issues relating to statutes of limitation, which is the period during which the lawsuit can be brought, also varied, and contributory negligence also could vary from state to state, and those would require diverse rulings by the court. So the court concluded in the Rose case that the action was particularly ill-suited for prosecution as a class action, but it remains to be seen what effect, if any, class action lawsuits against other manufacturers for drugs or implantable devices would have on class actions, particularly when dealing with implantable or implanted devices. The plaintiff may have difficulties in getting jurisdiction over the defendant. Here there must be sufficient minimum contact for the judge to exercise jurisdiction. Simply placing the implant device into the stream of commerce between states with no knowledge about where the patient who ultimately receives that product will reside may not be adequate to allow jurisdiction over the defendant in the plaintiff's home state.
Let's deal with the subject of doctors and hospitals now as defendants. Do they have specific legal problems in this area?
Doctors and hospitals, if we look at the warranty cause of action, here a warranty cause of action cannot be sustained against the doctor or the hospital in general. The courts have generally held, Steve, that the sale of the device, as we indicated earlier, is incidental, and this is provided by the hospital or the doctor, and therefore they are not subject to the warranty cause of action. And let me conclude, if I may, about this area, that the implantable medical devices have improved immensely and prolonged life in case of pacemakers. But when these medical wonders fail to perform as intended, the determination of legal liability translates into who shall bear the cost: the manufacturer, the hospital, the physician, or the patient. And the final answer will surely have profound effects on the future costs and availability of implantable medical devices.